You know that moment, right? You're settling in to stream a movie, maybe download a new game.
Yeah.
And you see those little age ratings pop up or content warnings.
Or even in a bookstore, you might see an advisory on a publication.
Exactly. And we often just, click past them or barely notice, but behind them, there's actually a whole legal framework.
A pretty complex one, designed to guide us and also protect us.
And that's what we're digging into today, something really important but maybe a bit overlooked. The Films and Publications Act 65 of 1996. Now, before you think, 1996, that sounds a bit dusty, here's the kicker. This act has been seriously updated. Most recently, on March 1st, 2022.
That's right.
Specifically to grapple with, well, our modern digital world.
Indeed.
Yeah.
It's definitely not just a static piece of paper. It's more like a living framework. It evolves.
Okay.
So our mission today is really to unpack this consolidated act, make it clear,
Right.
look at its core purpose, walk through the key bits, give some legal context, look at what it actually means for creators and for us as consumers, and why it matters in the real world.
Good.
So whether you're just curious about how content gets regulated, or maybe you're a law student needing to get a handle on this act, we'll break it down. Plain language, but also the necessary legal terms and some examples.
Perfect. So what's in it for you listening? Well, by the end of this, you should really get what the act does, how it works.
And why it matters.
Exactly. Why it matters in your daily digital life and how it tries to keep stuff accessible but also safe. It's about informed choices, but also protection.
A balance.
Okay, let's unpack this.
Right.
So the Films and Publications Act 65 of 1996, originally signed way back on October 30, 1996.
Yep, quite a while ago now.
But as we said, it's seen a number of amendments over the years, which really shows it can adapt, right?
It has to, really. And those recent changes, effective March 1st, 2022, they came from the 2019 Amendment Act and also took some cues from the Cybercrimes Act of 2020.
So it's definitely not a museum piece. It's actively being shaped by, well, the world we live in now.
That's a really crucial point. The fact it's updated to 1st March 2022 isn't just a footnote. It signals its ongoing relevance, especially with how fast the digital world changes. And it's interesting how the Act keeps redefining itself, sometimes through seemingly small changes in wording.
Like what?
Well, for instance, swapping review board for appeal tribunal, or changing internet with a capital I to internet with a lowercase I.
Okay, that sounds minor, but I guess it means something.
It does. It's not just semantics. It reflects a shift in how things are structured, and importantly, it acknowledges the internet isn't just one thing, but this pervasive, fundamental way content gets shared.
Right, like electricity or water, almost, just there.
Pretty much. These updates are trying hard to weave the digital reality right into the legal fabric, so the Act stays effective even as tech races ahead.
That makes sense. So, thinking about these updates, what are the core goals of this act? What's it fundamentally trying to do in our lives beyond just sticking labels on things?
Well, the objectives are actually quite clear. First off, it aims to provide consumer advice to help adults make informed choices about viewing, reading, gaming for themselves, and importantly for kids in their care.
So those ratings and warnings are about empowering us.
Exactly, informed autonomy. Then, a really big one, it's designed to protect children from exposure to disturbing and harmful materials.
Crucial.
And also from, quote, premature exposure to adult experiences. It's a core protective function.
You're right.
Plus, the Act makes it very clear it wants to punish the use of children in pornography and the exposure of children to it.
So criminalizing it.
Absolutely.
Okay.
Criminalizing possession, production, distribution of child pornography. And finally, it sets up offenses for not complying with the Act itself.
Giving it teeth.
Precisely. Making sure there are real consequences.
Okay, so if I'm getting this, it's this careful balancing act. Adult choice and information on one side, and really strong child protection on the other. That sounds like a tricky line to walk.
It is.
So, to manage all this, the Act sets up some key bodies, right? Who are the players here? What do they do?
Certainly. To make it all work, the Act establishes 4 main entities. And they're all meant to be independent, impartial, without fear, favor, or prejudice, as the Act says.
Okay.
You've got the Film and Publication Board itself that's a juristic person, meaning it has its own legal identity.
Right.
Then there's the Council, the Appeal Tribunal,
Right.
which, remember, replaced the old Review Board. And a really significant addition from the 2019 updates, the Enforcement Committee.
Okay, the enforcement committee. That sounds like it adds some real muscle.
It does. It's key for accountability. So the council, for instance, sets general direction, issues classification guidelines, appoints the CEO and the classifier.
The people actually doing the rating.
Yes. And it oversees the board and, crucially, appoints the members of this new enforcement committee.
Got it.
The appeal tribunal, that's chaired by someone qualified and has 8 other members. Its main job is hearing appeals against decisions made by the board or findings from the enforcement committee. So it's an oversight body, a place for recourse.
Makes sense. And the enforcement committee itself.
Right. This is where the act really got beefed up. It's chaired by a retired high court judge and has members with legal, law enforcement, and digital tech expertise.
A serious panel.
Definitely. Its job is to investigate cases of non-compliance referred by the board. It digs into situations where the act hasn't been followed. Then it adjudicates, makes findings. It can impose fines, suspend registration certificates, or even refer serious matters to the National Director of Public Prosecutions for potential criminal charges.
Wow. Okay, so that really does strengthen things. It moves beyond just classifying to actual enforcement.
Yeah, exactly. A major shift.
So these bodies are the engine driving the system. Let's get into the classifications. How does the Act actually decide what we see, read, or play? What happens when something gets submitted?
Okay, this is where it gets practical. For publications, the Act says anyone can ask for one to be classified.
Anyone?
Yep. But there are important exceptions for genuine journalism from members of the Press Council or ads handled by the Advertising Standards Authority. It recognizes those self-regulation systems.
Right.
But here's a key bit.
Yeah.
Anyone else, excluding those exempt publishers who creates or distributes publications containing certain very specific types of content, must submit it to the board before distributing it.
And what kind of content are we talking about there?
We're talking about propaganda for war, incitement to imminent violence, or advocating hatred based on group characteristics that constitutes incitement to cause harm.
Okay, those sound serious. And they're not just, like, strong opinions, are they? These have specific legal meanings.
Absolutely. Critical distinction.
Yeah.
These aren't just unpopular views. Propaganda for war means actively promoting warfare.
Right.
Incitement to imminent violence means directly urging immediate violence. And there has to be a real likelihood it could actually lead to harm.
Okay, so a direct link.
Yes. And advocating hatred isn't just prejudice. It's promoting hostility against a group, plus inciting harm against them. These are high legal bars balanced against free expression rights.
That's a really important clarification. So keeping those serious categories in mind, what classifications can a publication actually get?
The classification committee has a few options. Content can be refused classification.
Meaning banned.
Essentially, yes. For distribution,
Right.
this happens if it contains child pornography, that propaganda for war, incitement to imminent violence, or the hate speech we just discussed.
Okay.
But, and this is vital, there's a caveat, if judged within context, the publication is a genuine documentary or has real scientific, literary, or artistic merit, or deals with a matter of public interest.
Ah, the context matters. Hugely. In those cases, instead of refusal, it might get classified with guidelines aimed at protecting children from anything disturbing or age inappropriate. This bona fide clause is crucial. It recognizes legitimate work, even if challenging, is different from exploitative material.
Right. So art or science isn't automatically banned just because it depicts something difficult?
Correct. Then there's the XX classification. This is for stuff like explicit sexual conduct that violates dignity, bestiality, incest, rape, degrading acts, explicit domestic violence, or extreme violence.
It's heavy stuff.
Very. And again, similar exceptions for bona fide works apply. Then you have X18, which is for explicit sexual conduct that doesn't hit the extreme X level.
Okay.
And finally, for content that's just considered disturbing or harmful for kids but not prohibited outright, the board imposes age restrictions and other conditions, basically guidance for parents.
That's a lot of nuance, especially with that context clause. What about films and games? Is it a similar process?
Largely, yes. The Act details it similarly. Distributors or exhibitors of films and games have to register with the board, and they must submit unclassified stuff for examination. The criteria are pretty much mirrored from publications.
So refusal, XX, X18, or age restrictions.
Exactly, based on similar things: child pornography, hate speech, sexual violence, etc.
Any exceptions there?
Yes, an important one. Broadcasters, regulated by ICASA, the Independent Communications Authority of South Africa, they're exempt from needing board classification for their broadcasts and online streaming.
Ah, because they have their own regulatory system.
Precisely. They fall under a different, though similarly focused, framework.
Okay, now this seems really key. The Act now directly tackles the digital world. The recent updates mention commercial online distributors, non-commercial online distributors, and explicitly include streaming, social media in the definition of distribute. What does this mean practically?
This is a huge shift. It's the Act really trying to get its arms around the, frankly, unmanageable scale of online content.
Right. How can you possibly classify everything?
Exactly. So the 2022 updates introduced some pragmatic solutions. One big one is self-classification for commercial online distributors.
They rate their own stuff?
Kind of, yeah. The board can approve and accredit these distributors to classify their own films, games, publications if they stick to the board's guidelines.
Okay, so there are rules.
Oh, yes. They have to tell the board about all their XX and X18 classifications.
Yeah.
And then those self-classifications are treated as if the board made them.
That sounds efficient, but maybe risky?
Well, it's a sort of trust but verify approach. It acknowledges the speed and volume needed online, but the board keeps oversight. They can audit the distributor's decisions. And if the distributor isn't complying, the board can suspend their accreditation. So there are checks and balances. It's a big practical change for global platforms.
And you mentioned international systems.
Yes, another pragmatic move. The Council can now approve the use of foreign or international classification systems. Think ratings from other countries or bodies if they basically line up with South Africa's ratings and guidelines.
That makes sense for global streaming services.
It does. It shows the Act adapting to content that doesn't care about borders.
So even with self-classification, there's oversight. But what about stuff that just slips through or is put online without any classification, especially on, the wilder parts of the internet? How does the Act handle complaints or prohibited content online?
That's where it gets proactive about online harm. Anyone can complain to the board about unclassified or illegal online content. Doesn't matter if it's from a big commercial platform or just some random non-commercial site.
Okay.
If the board thinks the complaint has merit, it can issue takedown notices using powers under the Electronic Communications and Transactions Act. So there's a mechanism to get harmful stuff removed quickly.
That's crucial.
Absolutely. And what's more, Internet service providers, ISPs, can be forced to give the board or the police information to identify who actually posted the prohibited content.
Ah, so they can track down the source.
They have to help do that, yes. And if the worst stuff, like child pornography, is hosted outside South Africa, the board has a mandate to refer it to law enforcement in that other country.
Giving it global reach for the most serious crimes.
Exactly. It extends its protective arm internationally, recognizing online crime doesn't stop the border.
That's incredibly important, given how much harmful stuff is online. Speaking of harm, the Act also got tougher on things like sexual violence, private sexual images, so-called revenge porn, and hate speech, right?
Yes, these are really critical protections with serious penalties. The Act now explicitly bans distributing private sexual photographs and films without the consent of the person in them, especially if the intent is to cause harm.
So, directly targeting revenge porn.
Directly. This gives victims clear legal recourse, and the penalties are significant fines up to $300,000 or up to 4 years in prison, or both.
Wow.
And ISPs have to help identify the culprits here, too. Zero tolerance.
Good. What about sexual violence?
Similarly, it explicitly prohibits creating, producing, or distributing films and photos showing sexual violence and violence against children, any medium, internet, social media, whatever.
Penalties.
Fines up to $150,000 or up to 2 years imprisonment. And, importantly, the Act clarifies, even if someone consented to the original image being taken, distributing it later without consent, especially if it depicts violence, is still illegal.
So consent to create isn't consent to distribute abusively?
Precisely. And this includes altered images, too, acknowledging deep fakes and digitally manipulated abuse. It's a strong stand against exploitation.
Definitely needed. And hate speech.
Same applies. Distributing any film, game, or publication that amounts to propaganda for war, incites imminent violence, or advocates hate speech, online or offline, is prohibited. Fines up to $150,000 or 2 years jail time. These rules clearly echo constitutional values, dignity, equality, safety.
Those are serious penalties. It's clear the Act is way beyond just age ratings now. It's actively fighting genuinely harmful, illegal content. You mentioned ISPs having to furnish info, but what else are they required to do proactively?
This is where the Act puts quite a heavy responsibility on ISPs, but it's vital.
Hmm.
Firstly, providers offering services specifically aimed at children, like chat rooms, they have specific duties. They must moderate those services and take reasonable steps to make sure they aren't being used for offenses against children.
So trying to prevent grooming, for example?
Yes, actively. They also have to display clear safety messages, give kids ways to report suspicious stuff, and report any indication of offenses to the police.
And if they don't?
Fines up to $50,000 or 6 months in prison.
Okay.
But then there's a broader obligation for all ISPs. They have to register with the board.
Right.
And they must take all reasonable steps to prevent the use of their services for the hosting or distribution of child pornography. That's a big one. If they become aware their services are being used for child pornography, or that war propaganda, incitement, or hate speech, they have to block access to it, report it to the police, and preserve any evidence.
That's a massive responsibility.
It is. And failing to comply carries really heavy penalties up to $750,000 or 5 years imprisonment, or both. It essentially makes ISPs frontline defenders against some of the worst online harms.
That's a truly significant burden, but you can see why it's necessary in today's world. They are the gatekeepers, in a way. It's just fascinating how this act, born in '96, has been so thoroughly reworked for issues that maybe weren't even fully imagined back then.
It really speaks to its ability to evolve. Its real-world significance comes from that adaptability, grounded in a clear legal context. It sets up a system that doesn't just classify, but actively fights illegal content, online and off. And things like extraterritorial jurisdiction, meaning a South African who commits these offenses abroad can still be prosecuted back home, that extends its reach even further. The constant updates, adding bodies like the Enforcement Committee, show a real commitment to keeping people safe, especially online.
So we've really journeyed through the Films and Publications Act, haven't we? From its basic goals, advice for consumers, protection for kids, all the way to these really robust tools for tackling online content regulation. It's definitely not some dusty old rule book. It feels very alive, very relevant, constantly adapting.
And what's really striking is that constant effort to find the right balance.
Yeah.
On one side, you've got providing consumer advice, empowering adults, allowing practical things like self-classification for online platforms to handle the sheer scale.
Recognizing reality.
Exactly. But on the other side, it's absolutely firm on criminalizing the worst offenses, child pornography, distributing private sexual images without consent, hate speech, sexual violence against children.
No compromise there.
No. It reflects a clear societal decision to protect vulnerable people and uphold basic dignity. And adding the Enforcement Committee with real penalties for non-compliance gives that commitment teeth.
So from those classifications you see everywhere to the massive responsibilities on your internet provider to fight child abuse material, this act really does touch so many parts of our lives, online and off, even if we don't always notice it. It's all aimed at creating a safer space, a more informed space for everyone, especially kids.
And connecting this to the bigger picture, it really makes you think, doesn't it? Technology just keeps accelerating. Content creation, distribution, it's more scattered, more global than ever.
Yeah, where does it go from here?
That's the question. How will laws like this one keep evolving? What are the next challenges for regulators trying to balance protecting people from harm, protecting vital free expression, and keeping up with a digital world that just ignores borders? It's a complex, ongoing conversation, definitely far from over.